that we are going to take a very short time.
As expected, proponents of constitutional changes through the BBI process have moved to the Court of Appeal, contesting the Thursday night High Court judgment. Attorney General Paul Kihara Kiriuki, through Solicitor General Ken Ogeto in the Notice of Appeal, wants the Appellate Court to shelve the High Court verdict pending the hearing and determination of the application. The government's chief legal advisor, while pushing for a stay order, said petitioners who contested the BBI process will not suffer any prejudice should the Thursday judgment be set aside. On the contrary, the Attorney General says respondents will be adversely affected if the orders granted on Thursday are implemented. ODM leader Raila Odunga too has moved to the Court of Appeal, and so has the Building Bridges Initiative National Secretariat through lawyer Paul Ngugi. According to the duo's Notice of Appeal, the 5 High Court judges usurped the sovereign power of Kenyans to amend the Constitution by determining certain articles of the country's supreme law that are unamendable, citing the doctrine of basic structure.
What that means is that if you ever want to amend the Constitution of Kenya, you will always have to go to the judiciary and ask them whether what you want to deal with is amendable or not. It's a basic structure. It's a decision judges will have to make every time anybody wants to amend the Constitution. So who owns this Constitution now? This Constitution is now owned by judges. They are now above people's sovereignty. It means that even if every single of the 15 million Kenyans decide that they want something in the Constitution, the judges are the ones who will determine whether they can have it or not.
According to Odunga and the BBI team, the court stopped an non-existent popular initiative since the mandate of the BBI Steering Committee, established by President Uhuru Kenyatta, lapsed in June 2020, months before the process of signature collection and submission to IEBC for verification kicked off. They also faulted the 5 High Court judges for allegedly ignoring evidence presented, confirming that the over 4 million registered voters who appended their signatures in support of the BBI process had read and understood the Constitution Amendment Bill 2020.
Adventurism is just a polite way of saying that the judges played politics. That's just what people are being polite by saying that this is judicial activism, this is adventurism. Let's call it what it is. It's just pure politics.
The Thursday judgment indicted President Kenyatta for violation of Chapter 6 of the Constitution on Leadership and Integrity by spearheading the popular initiative, a position Odunga and the BBI team differ with, insisting Junet Mohammed and Dennis Waweru were the promoters of constitutional changes through the BBI popular initiative drive. The appellants also won the Court of Appeal to determine if IEBC, as currently constituted with 3 commissioners, could carry out its functions, including verification of voters and conducting a referendum. According to Odunga and the BBI team, the judges sidestepped earlier decision made by High Court judges on composition of IEBC, validity of BBI, and immunity of the president. County Assembly's Leadership Forum criticizing the Thursday night BBI shocker.
The judgment does not acknowledge that a constitution is a living document that must be responsive to the needs and desires of a society at any given time. It presupposes that Kenyans are prisoners of the 2010 Constitution, and the 2010 Constitution was made for a tiny minority of Kenyans, and in this case the judiciary and civil society groups, not the larger majority of Kenyans.
Francis Gashuri, Citizen TV.